Hello and welcome to another session on current affairs. In this session, we are going to understand the recent current affair issue, prison reforms. We are well aware that this topic comes under General Studies Paper 2 of Civil Service Examination Mains under the section issues regarding issues rising in the implementation of policies, and this is also covered in Indian judiciary and even Indian constitution. In this topic, we are going to understand why it is in news. We will explore what is the philosophy of punishment, and we will try to understand why more prisoners in India or why our prisons are overcrowding and measures in this problem, with respect to this problem. And it is well known fact that Indian prisons are overcrowded, and this was recently highlighted by Hindu newspaper in its data point. It explained that in 2021 crisis, in specifically Uttarakhand, Uttar Pradesh, Delhi, occupancy rate is almost 180%. Further, we will try to understand what is this exactly, why this situation is exactly happening in India. And to understand that, I would first of all want to explain what is the philosophy of punishment. And philosophy of punishment was explained by Justice Markandeya Kajju in one of his observation, and he said the idea of punishment is to create fear, to bring reform, of course to prevent the mistake again, and last but not least, it is for retribution, meaning you have to pay for your own mistake. So these are the four elements one can find in the punishment itself. But are our jails creating any of this? That is a question we have to debate and to be discussed. The philosophy of punishment clearly highlighted that it should create fear, reform, prevention measures or retribution. We can say retribution may be going to some extent, but are we achieving this success or these elements? Further, what we can understand is what we understood from the philosophy of punishment, that jail should bring any of this element. Unfortunately, our jails are not able to achieve these elements in the philosophy of punishment, because our jails are already overcrowded. Why Indian jails are overcrowded? What made our prisons to have more number of prisoners? So to be precisely, according to Government of India's data, I can quote here, throughout the India, 8.2% of population is in jail. And are we having enough capacity? Are we having enough capacity? And that is need to be discussed here. So 8.2% of population is right now staying in the prisons, and according to National Crime Records Bureau data, which is published by under the Ministry of Home Affairs itself, and this data clearly mentioned that our prisons are already overcrowded with almost 18.5% of its capacity. Of course, you can see the Hindu article and explains that in some state it is almost crossed 180% of its occupancy. It explains the grave situation in our jails. And what is further unfortunate thing is, within this population itself, 70% of the prison population are under trials. And by meaning of under trials, we can say that they are the people not convicted or not acquitted. They are in the jail because of some restrictions placed on them as per the laws. Now, if you compare this number with the developed countries, in United Kingdom, you will find around 11% of prison population as under trials. In USA, it is around 20%. But in India, it is almost 70%, which is very, very unfortunate also. Moving further, why we are having more number of prisoners or inmates in the jail? To answer that, we have to see this. That is, we do have low infrastructure, that is our capacity of jails are very, very low, and they are low and even not updated also. They are not upgraded as per the requirement of the rise of the crimes. Further, our judicial pendency, and you know that according to 2018 data of National Judicial Data Grid, around 3.84 crores cases pending in India, and within that we have to understand that as per Vidhi Legal Center very recently in 2021, it said more than 4 crores cases are pending in India. And we all aware about this quotation given by Martin Luther King Jr. said that justice delayed is nothing but justice denied. And high judicial pendency, the more number of cases in the judiciary is one of the reason for this under trials too. Poor capacity, we already understood this poor capacity in terms of infrastructure, and later the investigation phase. You know very well in 2006 Supreme Court of India in Prakash Singh case versus Union of India stressed about police reforms, and it is also highlighted that police reforms are needed because we need to differentiate, or we need to separate this investigation police from investigation police and law and order police system. Because investigation, when there is a separate investigation wing in the police department itself, then investigation will go at faster speed. Unfortunately, you know very well that Supreme Court even observed in time and again, the same police in India has to do two jobs, protecting law and order, and he has to take care about this investigation also, which is burden and even which is not efficient too. And our investigation phase also doesn't include high amount of technology in terms of forensic utilization, in terms of technologically driven investigation. Further, our prisons are very understaffed and even underfunded. It was highlighted in the Government of India's data itself. Our prisons are almost underfunded and even having more number of fund requirement also. So underfunded, understaffed is also one of the reason. And poor awareness about laws. According to NLU Delhi report, one of its research report mentioned that prisoners in jails doesn't aware about their rights. Particularly, there is a right called as section 436 CRPC, and which allows to get the bail, but it is not this right is not aware by these people itself. Further, high restrictions on bail, which is also rising number of prisoners. In addition to that, I would like to add that in Indian society, if you observe crime data, NCRB crime data, it is time and again highlighting that there is a huge rise of crimes in India. Okay, this rising crimes is not at all matched with the rising police number, of course with the prisons upgradation also. This is also one of the reason, the social structure, the social element of rising crimes in our society is also one of the reason for the more number of prisoners. Having a clear picture about this, why prisoners are more, let us try to understand the second aspect of our discussion, that is what are the different measures we can suggest to reduce the prisoners overcrowd situation in our jails. According to Law Commission 268th report, it mentioned that the people whoever involved in petty crimes or small crimes can be released if they complete one third of their punishment period. Further, Law Commission also recommended that for long-term punishment prisoners, so there can be half of the period can be considered for the release. Further, Supreme Court raised concerns over underutilization of bail provisions. And you know very well that Supreme Court clearly stated in this Balchand Balai case in 1971, it stressed that the basic essential or the basic rule is bail for a prisoner, not at all jail. And this is very well evidently highlighted even very recently by Supreme Court of India, and where the case is investigated about bail. And even Supreme Court of India clearly stated that bail is essential and jail is optional. And Supreme Court clearly stated that only in certain situations only we have to go for jail, or else we should not go for jail, we should go for bail itself. Because if you arrest a person, Supreme Court clearly believes that if you are arresting, you are taking away his rights, right to life and liberty, which was mentioned in Article 21. And of course, the arrest is also considered to be humiliation. So to reduce that situation, Supreme Court clearly stated that bail provisions should be clearly adopted. I just want to add one more Supreme Court judgment in 2022 itself, this year itself, Satendra Kumar Antil case, in Satendra Kumar Antil case. And in this case in 2022, Satendra Kumar Antil versus CBI, it clearly stated that there is a need for new bail law on the lines of United Kingdom Bail Act. So there is need for new bail act in India. Okay, and this was clearly stated by the Supreme Court in its recent judgment also. And it is also highlighted that there should be a well awareness about section 436 of CRPC, and people should aware about it. And here there are guidelines by Supreme Court to use this CRPC 436. The guidelines are whoever completed his punishment, half of his punishment, he is eligible to get the bail. So whoever completed half of his punishment tenure can get the bail, and he has that option also. Unfortunately, this was not properly followed by the jail officials. Further, Supreme Court also mentioned that the bail amount can be reduced for the people who are not able to pay in the position. In addition to this, it also mentioned that the undertrials, whoever unable to produce a person on their behalf to sign the documents, bail documents, they can be self-attestation. That is enough. So Supreme Court gave this self-attestation and also bail provisions and reduced bail amount also. All these things were clearly stated time and again, but still they were not implemented properly. Okay, so you can see this self-attestation or reducing bail amount, or it can be eligible if they complete the half of the tenure. All these things are not implemented properly. Further, I would like to say this: All India Commission on Jail Reforms clearly stated India can explore open jail concept to reduce this overcrowdedness or occupancy. So this open jail concept somehow has synergy with the United Nations organization Mandela rules also. You know, United Nations put forward Nelson Mandela rules for prisoners, and it said that self-discipline can be incorporated among the prisoners. So self-discipline can be incorporated among the prisoners. So there is an option for them. And moving further, you have Justice Amitava Ray. Justice Amitava Ray clearly gave a series of guidelines. Justice Amitava Ray clearly provided a series of guidelines against this rise of prison population. You know very well that he suggested to have suggested to have fast track courts to reduce the pendency, fast track courts to reduce the pendency, and also it suggested that if the offence is small, no need for no personal bond is needed to get the bail, no personal bond is needed to get the bail. Only on the large crimes or crimes which are cruel in nature, only such kind of crimes should have personal bond. And further, it also stated that it is high time to have national mission for justice delivery. And you know very well that this was implemented in 2011 in the name of National Mission for Justice Delivery and Legal Reforms. National Mission for Justice Delivery and Legal Reforms, and these are set of reforms by Government of India. So National Mission for Justice Delivery, National Mission for Justice Delivery, just a second, National Mission for Justice Delivery, National Mission for Justice Delivery and Legal Reforms clearly stated a set of rules. It stated that every jail should raise its infrastructure. Every jail should raise its infrastructure. Every jail should raise its infrastructure. Further, it also stated that the jail should have ICT correction, information communication and technology for online petitions and for online bail applications like that. So their Amitava Ray committee recommendations are quite essential to implement, and Government of India started this project of National Mission for Justice Delivery and Legal Reforms, but still it is not very much effective, and government has to intense its action in this regard. Further, we also have adopted, government also recently announced, not recently, couple of years back, announced new prison manual administration, new prison manual, and this new prison manual talks about a new set of administration rules. Apart from that, it want to bring the new management practices in the jail. And of course, we have further next set of measures like rising budget. We can also suggest rising budgetary allocations for the prisons, and constructing new buildings is also essential for us. Last but not least, incorporating technology by, you see, the concept of e-prisons, and also we have CCTNS, which we can also help the government in rising, or you can say the government in connecting the courts very effectively. It can also help a lot. So by taking all these measures, and we can also reduce the pendency, overcrowding of prisoners. Apart from that, I would like to suggest that government has to take Article 39A directives very seriously, so that the directives mentioned that government has to, state has to support the weaker sections in getting legal assistance. So if we implement all these measures by taking the aforementioned reforms, definitely we can reduce the occupancy in the prisons, and we can bring a proper justice to the constitutional values, particularly to the Article 21 of Indian Constitution, which guarantees right to life and liberty. That's all for this week. Next week we will meet with one more topic in the current affairs. Thank you so much, and Jai Hind. Thank you.